and family wealth structures are becoming increasingly complex, understanding how to safeguard your legacy through effective trust and estate administration has never before been more important. Today, our expert panel will unpack key trends, challenges, and practical considerations to help you plan with purpose, manage with confidence, and protect with foresight. Guiding us through this session is our moderator, Sarah Nkwana. Sarah brings over 18 years of experience in the financial services industry, with a career spanning banking, insurance, and fiduciary sectors. She holds multiple qualifications in banking, wealth management, insurance, strategic leadership, and learning and development. Beyond her professional career, Sarah is a registered industrial and organizational psychologist and a PhD candidate. She also serves as the president of the Top CEMS Club, a society for UNISA's top 100 performers. With her extensive expertise and dynamic leadership style, Sarah is perfectly positioned to steer today's conversation. And now onto our panelist introductions. We start with Amina Khan, the Regional Manager for Trust Services. As the Regional Manager for Trust Services at ABSA, Amina oversees the strategic and operational delivery of fiduciary offerings across the Pretoria region. With over 13 years of experience in the fiduciary environment, 3 of which have been dedicated specifically to trust services, she leads high-performing teams, drives business growth, and ensures regulatory compliance and governance excellence. Our next panelist is Beverly Jackson, the Manager of Trusts. Based in Cape Town, Beverly brings more than 20 years of experience in fiduciary services, including 14 years in trust management. She specializes in trust administration, regulatory compliance, and the strategic structuring of trusts to meet both client and fiduciary objectives. Her work bridges collaboration between legal, financial, and tax professionals to ensure efficiency and transparency in every trust solution. And our final panelist for today is Shireen Jansen, the Regional Manager for Estate Services. Shireen serves as the Regional Manager for Estate Services, where she oversees the end-to-end administration of deceased estates. With a focus on compassionate client engagement and operational efficiency, Shireen ensures that every estate matter is handled with professionalism, transparency, and care. Her leadership in estate management helps clients and families navigate complex legal and administrative processes with confidence and dignity. With such a knowledgeable and experienced panel, we're in for a truly informative session. As always, our aim is to keep this webinar as engaging as possible, so please be sure to add your questions to the chat. We will present them to our panel at the end of the session so we can gain further insights from their vast expertise. I now hand over to our moderator, Sarah, to guide us through today's discussion on future-proofing your legacy. Thank you, Sarah.
Great. Good morning to you, Verity, and thank you so much for helping us put this webinar together. Just want to greet all our attendees a very good morning and a very warm welcome to the final session of our series, Preserving Your Legacy. Sorry, I think we've got somebody who's unmuted. Hey. So as I was saying, that we are now in our final series of Preserving Your Legacy, and the first 2 sessions that we looked at, we really focused on how financial planning supports administration, as well as what happens if a will go wrong. Today, I'm very excited that we're going to take it a step further, and we're going to look at future-proofing your legacy by looking at how trusts protect your assets, as well as your loved ones, long after an estate has been finalized. So I'm really looking forward to engaging with Shireen, Amin, and Beverly. So I'm going to start by unpacking why trusts matter beyond estate administration. And Shireen, I want to start with you. Can you perhaps take us through why do you think trusts matter beyond estate? What should families consider, including a trust, in a legacy planning? Why is it important that I, as my family, should consider including a trust in a legacy planning?
Good morning, everyone, and thank you for that question, Sarah. So I just want to start off by highlighting a few aspects relating to the estate administration process. So when a loved one passes away, their estate enters into a very prescriptive legal process, which involves, amongst others, the reporting of the estate to the Master of the High Court, letters of executorship being issued, the whole collection and valuation of assets, summarizing the assets and liabilities in the estate into a liquidation and distribution account. Once the account has been approved and it goes through the mandatory inspection processes, is the executor placed in a position to distribute, settle all claims and distribute the assets to the beneficiaries. And this is typically where the estate administration process comes to conclusion. And this is also where the transitional gap emerges for specifically minor beneficiaries and also um, beneficiaries who have special needs. So whilst the estate administration process is focused on distributing assets to the loved one of the deceased and the rightful heirs, the family's needs do not necessarily end here. Often some common ongoing concerns relate to care and financial provision for minor beneficiaries, as well as I mentioned earlier, beneficiaries who may have special needs. There's also the ongoing maintenance obligations such as school fees and the settlement or payment of medical expenses. And this is where a trust becomes essential in terms of making sure that their transitional gap is fully addressed and that the loved ones of the deceased are not placed in a worse off position. I also want to mention, though, as much as a trust is, an essential tool in estate planning, it is not an automatic consequence, nor is it an instrument that automatically becomes available for the benefit of minor beneficiaries. In the absence of a valid will, or if the will does not make provision for a trust to be created, the inheritance will be paid to the guardian's fund, which is held with the master of the High Court. So whilst the estate administration process is essential for settling a deceased affairs, it is not designed for ongoing financial management or protection. Trusts offer a flexible, secure, and enduring solution that bridges the gap between estate finalization and the long-term needs of the family. So that's it in a nutshell, Sarah, in terms of the importance of having a trust, especially from a continuity perspective after the estate has been finalized.
Thank you so much for that, Sherry. So just as you've highlighted the importance of having a trust beyond estate. But how does now your trust complement the work that happens during estate administration?
Okay. Sarah, a key point I'd like to touch on is Section 26(1) of the Estate Administration Act, which places or allows the executor to look into the maintenance of the household of the deceased with certain considerations being made, such as we be looking specifically at the household of the family that were financially dependent on the deceased. The request for maintenance must be reasonable and affordable by the estate. And also it cannot prejudice any creditors or the rightful beneficiaries. It may also be necessary for the executor to refer any request for maintenance to the Master of the High Court for approval. But there is the executor is placed in a position to manage these needs, but though it is temporary. So the advantage of a trust is that the continuation of the management of these needs will fall within the trustee space, and it will benefit the beneficiaries in that the trust will maintain it, will manage it, and is according to how the trustee basically reads, will ensure that that continuity is basically in place. Also, I want to focus on the fact that whilst the estate administration process is ongoing, the executor is responsible for the custody and the safekeeping of the assets in the estate. This responsibility will also then fall within the trustee's hands once the estate has been finalized and the inheritance now vests in the beneficiary. If they're not capable of looking after these assets, the trust will ensure that they are safeguarded until such time that they are able to, until the trust terminates, or they're able to manage them by themselves.
Yeah, that is quite a lot of information, but it does help. I mean, I'm just thinking of myself as a simple man in the street and trying to understand. So the whole concept of estate administration is really winding up the deceased estates. But in that, there are still assets. You could still have minors, and that process needs to still continue and making sure that that legacy is protected. And that gets done in the trust space. So once an estate is finalized, the family needs often then continue, especially if there's children or there's complex family structures that are involved. So trust really bridged the gap, right? So just to take this further, Beverly, I just want to come to you. So what are some of the key reasons trust become vital after an estate process?
Thank you, Sarah. So, really, if we consider what is a trust, trusts are an essential tool in the South African estate planning environment. As was alluded to a little bit earlier, they provide a form of protection, structure, and continuity, especially in complex family and financial situations. Properly established, trust can ensure that your wishes are respected, your beneficiaries are cared for, and your wealth is preserved across generations. So, to get back to your question, some of the key reasons for utilizing trust in your estate plan are as follows. They assist with the protection of minors. In South African's context specifically, minors cannot legally inherit or manage assets. So without a trust, funds may be paid into the guardian's fund. A testamentary trust created in a will helps to manage assets until the minor reaches majority, which is 18 at the moment, or a specified age. Trusts also help support vulnerable dependents, example, people with disabilities. So a special trust, specifically type A trust, which is a classification for SARS purposes, is available for individuals with permanent disabilities. These special trusts are taxed on a sliding scale, similar to that of individuals. In terms of the way forward, a trust then ensures lifelong financial support and may preserve eligibility for government benefits. If we consider our blended families, trust can assist with managing complexity in blended families. Some South African law may not always adequately protect stepchildren or second spouses, as an example. A trust, therefore, allows for tailored asset distribution of your assets. As an example, a testamentary trust can provide for a surviving spouse while preserving capital for children from previous relationships. And I think then more specifically, lastly, I'd like to mention that we need to consider conflict. As unpleasant as it is, trust can assist with conflict avoidance and control over assets. So trusts are governed by the Trust Property Control Act, much like the administration of estates is governed by the Estate Administration Act. Trust deeds, simply put, the rules of the trust, provide clear instructions to trustees as to how the trust is to be administered. Appointing independent trustees, like Absa Trust, also helps to ensure impartial decision making and administration. Thank you, Sarah.
Thank you so much, Bev. It's quite clear. You've touched on where trust plays a huge role in terms of minors, in terms of vulnerable dependents, as well as blended families. I just want to see the real life example of this. And I'm going to come to you. Can you share with us examples of how trust have supported families in complex estate situations?
Certainly, Sarah. I'll share a few real-life inspired examples that highlight their value. So in an example of a blended family with children from previous relationships, a testamentary trust ensured that all children were treated fairly. The trust provided income for the surviving spouse and preserved capital for equal distribution amongst all children, thereby avoiding potential conflict and ensuring long-term fairness. In another family, they used a testamentary trust to protect the inheritance of two minor children after the sudden death of their father. The trust covered their education and living expenses, with professional trustees ensuring responsible asset management until the children reached adulthood. A special trust A was established for a child with a cognitive disability. This trust provided for her lifelong care while benefiting from favorable tax treatment. It ensured she would be financially secure without compromising her access to state support. And for one family, an interviewer's trust was used to manage a family business and a property portfolio in a blended family context. It provided income to the surviving spouse and preserved capital for all the children, with independent trustees ensuring impartiality and continuity. So these are just a few examples that show how trusts can protect vulnerable dependents. It can manage blended family dynamics and preserve wealth across generations. And with the right structure and professional trustees like Absa Trust, families can avoid disputes and ensure their legacy is honored with clarity and care. Thank you, Sarah.
Thank you so much, Amina. And I'm starting to see how one can future-proof their legacy through trusts. And I have to say, even before joining this industry, whenever somebody spoke about wealth preservation, I was just thinking investments. Or when I thought insurance, I was just thinking funeral policy. And there's actually more to this. And it's quite nice to know that you can have a will in place. And with your will in place, you can use trusted professionals who can help you administer your estate and even beyond death, that your legacy can be preserved. And I mean, from the examples that have come through here, from complex families, minors and vulnerable dependents, clearly there's different types of trust that are at play here. And I just want to just touch on that. And Beverly, if you could just take us through the different types of, or the main trusts that are available. So if I'm an ordinary man on the street, you mentioned Inter Vivo Trust. What is that? What is testamentary trust? When do you open and when do you create the trust and so on? Can you just maybe perhaps take us through that, Beverly? Just the different types of trusts that are available.
Thank you, Sarah. So you mentioned a few types of trust, and I'm going to touch on an inter vivos trust as well as a testamentary trust. So let's start with an inter vivos trust. So an inter vivos trust is also called a living trust or an IV trust, but they all in fact refer to an inter vivos trust. There are different parties to a trust, and a key party is called the founder, is the creator of such type of trust. In an IV trust or an inter vivos trust, the trust is created during the founder's lifetime with the rules of the trust documented in the trust deed itself. This type of trust is often used for asset protection, Sarah, for tax planning, wealth management, and is ideal for ongoing family support and managing complex family dynamics. So testamentary trust, what is the difference? So testamentary trust really is established or created in your will and activated upon the death of the founder. It is commonly used to protect minors or dependents, and it really is crucial for blended families and vulnerable beneficiaries.
Great, thank you for that. So how would I then know what factors determine which trust structure should suit my needs as a client? Amina, perhaps you could take us through that?
Sure, Sarah. So when advising clients on trust structures in South Africa, the key is aligning the trust type with their goals. Factors like family dynamics, estate complexity, and cost considerations all play a role. Inter vivos trusts offer flexibility for asset protection and tax planning, whilst testamentary trusts are ideal for protecting minors or vulnerable heirs. Professional setup and the appointment of capable independent trustees are critical to ensure compliance, to avoid legal pitfalls, and to protect beneficiary interests. Thank you, Sarah.
Great, man. Thank you for that. So I just want us to bring this to life now. So it's quite clear that the trusts are not just legal structures. They're actually practical tools that can help us change outcomes of the families. Can you share then an example where a trust changed the outcome of a family, Beverly?
So, Sarah, I can share with you 3 different scenarios, and I'll start with an example where testamentary trust was crucial. So the testamentary trust in this particular instance secured the education for minors. Mr. Mtembu was married, died suddenly in a car accident. He left behind his wife and 2 minor children. And as we said, minors are children under 18. As he wanted to ensure that his children were cared for financially, His will established that a testamentary trust be created for his 2 minor children. On his death, his children who were still minors, the children's inheritance was paid to the trust to be administered for their benefit. The trustees, via the trust, ensured that the things like the children's school fees, the uniforms, and university tuition was covered. The trust also delayed access to capital until age 25, promoting financial maturity. The impact of what I've just mentioned is that the children received consistent support without financial disruption, and the estate was administered smoothly. In my second example, trust can assist with preventing blended family conflicts. So, a client divorced from his first wife fathered a child with the first wife. Unfortunately, the marriage subsequently ended in divorce. A few years later, the client remarried, but died after being married for about 2 years with his second wife. Fortunately, he created a testamentary trust in his will, and the trust provided for the maintenance needs of the surviving wife while preserving the assets for his daughter. And then lastly, Sarah, multi-generational trust can preserve high-value estates. So in this particular example, the client, a successful entrepreneur, created an inter vivos trust and transferred 50 million rand in property, which included a farm and investments into it. He appointed a mix of professional, independent, and family trustees and made use of his annual donations to the trust within the tax-free limit. In his trust deed, he specified that income could be used for education, housing, and healthcare of his descendants. On his death, no estate duty was payable on the trust assets, and his children and the grandchildren benefited from the trust without the assets ever forming part of their personal estates. Thank you, Sarah.
Thank you so much for that. And I'm just sitting here and wondering now, what could have happened if this trust wasn't in place? And Amina, maybe you could help us here, looking at Beverly's 3 examples that she shared. What then could have happened if the trust weren't in place?
That's a really important question, Sarah, and it highlights why proper trust planning matters so much. So if we look at the first scenario, if the deceased hadn't set up a testamentary trust, his children's inheritance would likely have gone into the guardian's fund. That means a limited flexibility and financial continuity. The kids might have struggled to access funds for school fees or university costs when they needed it the most. And without the delayed access to the capital, they could have received large sums of money at a young age before they were actually financially mature to manage those funds. In the second scenario, without the family trust, the estate could have become a legal battleground. The children and surviving spouse might have had conflicting claims, leading to emotional strain and possibly expensive litigation. The trust helped to avoid that by clearly outlining how the assets should be managed and distributed. And in the third scenario, the family's estate could have been fragmented over generations, with each death triggering estate duty, possible capital gains tax, and asset division. That would have weakened the business and possibly led to the sale of the farmland. The trust preserved the estate, it kept it intact, and allowed it to grow across generations. So in short, without those trusts, each family could have faced financial disruption, legal conflict, or the loss of long-term value. So trusts aren't just legal structures. They are tools for stability, protection, and also peace of mind. Thank you, Sarah.
Thank you so much. I mean, that is really a mouthful. I'm sitting here and I'm thinking to myself, a lot of people really don't want to think about death or think beyond death. But as parents, we bring children into this world. And much as it's not a topic that is popular or we want to discuss, these are really critical topics and things that we need to consider and think about. And there is quite a lot of us who are getting now a lot of knowledge about this, and everybody attending online. My question is now, what would be the best practice, for families and advisors? What is the next step? If I really want to future-proof my legacy, if I really want to make sure that I don't leave my loved ones where we end up with there's conflict or there's legal issues, or you end up with a minor sitting with a lot of money and they don't know what to do with it. I've seen stories where minors, not even minors, even if it's young adults, inherit large sum amounts of money and they end up blowing it in a year and the future is not there. So I think this takes me to, thinking about how do families and advisors ensure their will and trust are aligned and effective. And Beverly, I'm going to bring this to you. What are the top best practices when establishing and reviewing a trust?
Sarah, so I think I'll start off with answering by saying be honest in your discussion with your financial advisor. Their advice is based on what you share with them. Secondly, I would say review your trust deed regularly if you have a trust. Ensure your trust deed reflects your current family dynamics and goals, because this could change over time. And then lastly, appoint professional executors and trustees. The winding up of an estate and the administration of trust is extremely complex and very specialized. It is important, therefore, that you choose individuals or institutions, Sarah, with legal, financial, and fiduciary expertise. Before a trustee may act on behalf of the trust, they must be formally appointed by the Master of the High Court, who also has conditions for the appointment of trustees. And then lastly, an independent trustee are essential in family trust to ensure impartiality as well as compliance. Back to you, Sarah.
Yeah, which makes it all the better and best why you should actually appoint your professional trustees. What are some of the common mistakes families make in this process in appointing trustees, Amina?
So there are several recurring pitfalls we see in South African trust practice, Sarah. One of the major issues is failing to regularly review and update wills, especially after life events like marriage, divorce, or the birth of a child. This can lead to misalignment between the will and the trust, causing confusion or disputes down the line. Another common mistake is appointing friends or family as trustees or executors without considering their financial literacy, their impartiality, or their knowledge of fiduciary services. Professional trustees and executors bring essential expertise and objectivity, especially in complex estates. Additionally, trustees and fiduciaries are subject to strict governance protocols. We are required to report to various regulatory bodies and undergo frequent internal and external audits to ensure that we remain compliant and maintain high fiduciary standards. We also see families neglect to formally transfer assets into the trust, which means that those assets remain in the founder's estate and are exposed to additional costs and delays. And finally, there's often a lack of collaboration between financial planners and administrators, which can result in fragmented estate plans. So a coordinated approach ensures that the trust structure supports the client's broader financial and legacy goals. Thank you, Sarah.
Thank you so much, Amina. I want to shift now to Shireen. In your estate space, are you able to give us an example, or please give us an example where a trust is not in place beyond a estate administration process?
Yes, certainly, Sarah. So we are actually dealing with a matter right now where two sisters drafted individual single wills nominating each other as the sole beneficiaries and also guardians of their minor children. Sister A died, and the inheritance was transferred to Sister B, who, as soon as the property was transferred, redrafted her will and left all the assets, including the property and the assets that she inherited from Sister A, she left to her own children. And unfortunately, the daughter that the Sister A had was not taken care of or provided for. And this has now resulted in a legal battle where the daughter now, who has turned who is now above 18, is now contesting the will because she believes that it was not her mother's intention to exclude her from inheriting from the estate. So I do believe that the sisters intended or had an agreement that they would protect each other or look after each other's assets as well as their children. But this is a good indication of how something turned quite badly, because we're now sitting with a beneficiary that's left with absolutely nothing as a result of how the wills were drafted. I also just want to share a bit on the drawbacks of funds being placed in the Guardians Fund, and I elaborated on that. So it is mandatory in the absence of a trust, and if the beneficiary is still a minor, that the funds be placed with the Guardians Fund. I personally visited the Guardians Fund to assist the beneficiary with withdrawing funds that were placed with the Government Institute, and it's a very cumbersome process. It involves the completion of a lot of forms. The queues are long. The master systems are not always operational. And if you look at basic needs like the payment of school fees or even medical needs, where the need is quite urgent and requires immediate attention as well, it is quite sad, to be faced with such a prolonged process before you are assisted. So really, I cannot emphasize enough, and Amina and Beverly has covered it quite well, the importance of making that consideration when one is actually looking at wealth planning and wealth preservation as well. Thank you, Sarah.
Thank you so much. I'm really hoping, I'm sitting here and I know that I am in this industry, but every time I get to hear these stories, every time complaints land on our desks and we try and help people, many a times we find that they blame the system, but the lack of proper planning and putting trust in place, making sure a proper wills drafting and estate planning is critical to avoid all of these things. And Sharon, your example of sitting in the queues with the Guardian funds and it taking longer. So there's really quite a lot to consider when you do this financial planning. And I really want to urge each and every one of us, to go back, read about these things, ask your financial advisor, speak to your trust people that they can help you, that you do your proper planning. But I think there's one burning question, and I know it came up in most of the webinars that we've had last year and even this year. It's all about tax and trust. And Beverly, I'm going to ask you to take this for me. How are trusts taxed in South Africa?
Thank you, Sarah. That is quite a big question and a burning question for many of us. So in South Africa, most trusts are taxed at a flat rate of 45% on retained taxable income. So this would exclude income that was allocated, paid, or vested in resident beneficiaries throughout the tax or the financial year. Special trusts, however, such as those created for the benefit of a person with a disability or minors, are taxed on a sliding scale similar to that of individuals. Thank you, Sarah.
Thank you so much for that, Beverly. And I want to move to Amina on the compliance, because this is quite a big, the trust aspect of it and compliance. It really is a big thing within trust. So given the increasing regulatory and scrutiny that and the evolving legal landscape around in South Africa, Could you just unpack the legal and fiduciary obligations that trustees must uphold, and particularly in the light of the Property Control Act? And also maybe the recent compliance development, like your beneficiary owner disclosures.
Thanks, Sarah. That's another great question. The trust landscape in South Africa has definitely shifted in recent years, and trustees now carry a much heavier compliance load than before. At the heart of it, trustees still have their core fiduciary duties, but today that duty is backed by a much more rigorous legal framework. So if we break it down, firstly, the governance is tighter. Trustees must be properly appointed and in many cases independent. A Chief Master's Directive and recent Constitutional Court decisions have made it clear that trusts require impartial oversight and enforceable governance structures. The tax reporting has expanded. SARS now requires trustees to submit detailed tax returns, including IT3T forms, for any distributions made to beneficiaries. And yes, the trustees are personally responsible for getting this right. Beneficial ownership transparency is a big one, Sarah. Trustees must now keep a register of all beneficial owners comprising of founders, trustees, and beneficiaries and submit it to the Master of the High Court. This is actually part of South Africa's push to meet global anti-money laundering standards. The FICA compliance is mandatory. Trust service providers actually are classified as accountable institutions, which means that they need to implement risk management programs, conduct customer due diligence, and monitor transactions. And finally, the international reporting obligations like FATCA and CRS mean that trustees must disclose cross-border financial data to SARS, including tax residency and account balances. So essentially, families should make sure that their trustees are up to the task. And it starts with choosing the right people, trustees who are not only trustworthy, but also legally and administratively capable. Professional fiduciary partners like Absa Trust can offer this expertise and systems that we need to stay compliant. Thank you, Sarah.
Thank you so much. And I think that was going to be my next question, to say, how do we ensure that their appointed trustees, or families ensure that their appointed trustees are adequately equipped to meet these responsibilities? So one sitting here now thinking that I'm going to create a trust and I'm going to put my family member. If I think of all the things that you've mentioned, from compliance, from regulatory, risk control, keeping of records, it is something that one needs to really think about. And what gives me comfort in choosing a professional trustee is the fact that they are regulated by legislation and there is recourse. In an instance where you choose a family, then what? So those are type of the things that we need to think about as individuals and as we're busy planning for our legacy. So I think for me then, taking this forward, and what would then be the call to action in terms of building a legacy that lasts? If there's a takeaway from today's session, its legacy is the fact that legacy is not about assets, it's about protection. It really is about structure and continuity. And trust provide a peace of mind for your and your values and wealth, for preserved wealth across the different generation. So Beverly, what would be the one action that all attendees should take after this webinar?
Sarah, so that's quite an important question, because it's great to have these sessions, but we are also called for action. So I would say schedule a sit down with your loved ones and review your will regularly. When you review your will, again, be open and honest with your advisor about your current circumstances. In doing so, your advisor will be able to give you the right advice based on these circumstances. Then review your trust deed. Legislation changes and court cases could have an impact on your trust. And then lastly, just make sure that you surround yourself with the necessary professionals to help ensure that your wishes and your legacy lives on. Thank you, Sarah.
Thank you so much. And Amina, from your side, if there's just one single piece of important advice that you could share or offer to our attendees, what would that be in terms of planning for the future?
So my advice, Sarah, would be don't treat estate planning as a once-off event. Make it a living process. Review both your will and your trust deeds and your trust needs regularly. Life changes, so should your estate plan. Too often, families set up a trust or draft a will and then forget about it, only to discover later on that it no longer reflects their wishes or their circumstances. And of course, partner with a trusted provider like Absa Trust Services, where estate and trust solutions are aligned, professionally managed, and tailored to your family's evolving needs. Thank you so much, Sarah.
Thank you, Amina. And I really want to thank my panelists and everyone who joined the call today. For me, this was really a really informative session, especially linking trust, because we always speak wills, we always speak estate planning, we speak estate administration, but looking at what is the bridge between estate administration and trust, and how do you ensure that there's continuity in your legacy. So really, really appreciate the information that has been shared. Verity, I'm not sure from our side if we've got any questions in the chat, or if anybody would like to unmute and share and ask their questions.
Thank you, Sarah. We have a number of questions that I think may have been answered already, but I'm going to present them to you anyway. The first is from Sia Bulela. She asks, in a family trust, can funds be invested in different investment vehicles to generate income back to the trust to provide for the future needs of the family?
Yeah, I'm going to ask Beverly. I see she was nodding her head there. Beverly, do you want to take that?
Thank you, Sarah. So, absolutely. Bearing in mind that a trust really, if to put it simply, is really just a vehicle. What one does inside the vehicle is what's important, like things like investments for that matter, creating the income that is needed to assist beneficiaries and support them during their lifetime. So, absolutely, once the funds are in the trust, bearing in mind that the rules of the trust, which is the trust deed, always need to be top of mind. The funds can be invested in various different vehicles, provided, as I said, the trust deed makes provision for that.
Yeah, and I see there's a follow-up question there on tax, and what are the tax implications for that?
So the tax implications is really dependent on what happens to the funds that are generated in that trust. SARS has a very specific definition as to what is regarded as taxable income. So where there's taxable income generated in the trust, and that money is paid to a beneficiary, as an example, for school fees or housing, it is most likely that that income will not be taxed in the trust, but in the hands of the beneficiary, and that generally is at a lower rate. Back to you, Sarah.
Thank you for that. Amina, I'm going to throw this one to you. What happens to the testamentary trust when minors are no longer minors?
So I'm going to assume the question relates to where the testamentary trust has already been set up. So the will itself will stipulate when a trust is required to terminate. So if the trust stipulates a specific age, and that is perhaps 25, which is over the age of majority, the trust will continue to run until the age of 25, despite the fact that the child has already become a major at the age of 18. So essentially, it will depend on what has been stipulated in the will. If the will stipulates that the the testamentary trust terminates on the age of majority, then it would be terminated at the age of 18. There are, however, some instances we find that testators fail to provide sufficient enough liquidity in the trust for it to last for the actual, stipulated time of the trust. And there are instances where the minor's needs need to be paid and the funds may deplete before the age of 25, or maybe even before the age of 18. So that is also a possibility, but essentially it depends on what the will has made provision for. Thank you, Sarah.
Great. Thank you, Amina. I see there's another question from Philip, but this relates to an opportunity. So I think that within the trust department, there are various roles that apply and may require different qualifications. I think what I could suggest is for you to perhaps send an email to us and, indicate what sort of role you're looking for within the trust services department. And maybe if I can ask Amina or Beverly just to type in the chat where they can email their resume and you guys will be in touch with them. I'm not sure if there's anybody else who probably perhaps would like to unmute and raise a question, or is everybody comfortable before we close off? And happy for more questions to come in and they can be tackled also post the webinar. Okay, I'm not seeing any hands, and I take it, I think the panelists have shared quite a lot of information and everybody's comfortable. So I really hope that this session has really provided valuable insights into how trust can help and secure your legacy and also protect your loved ones. So please stay connected with ABSA Trust team and more information and guidance on your estate and trust planning needs. So we are always available, happy to help you. And I think if there's one big lesson for me here is it's critical that we use our professional to help us, whether it be putting together a will where you do an estate planning with your financial advisor, and making sure that you appoint executors for your estate administration, as well as your professional trustees. Thank you very much, Verity. That is it from me and the panelists, and a very big thank you from the panelists as well for all their information that they have shared.
Sarah, I think I speak for everybody when I say thank you so much for sharing your expertise and taking the time to be with us today for such an important topic. I hope that next year we can explore this in-depth topic again. Wishing you all a wonderful day ahead. Thank you.
Great. Thank you, everyone.
Bye.
Thank you so much. Bye.
Thank you. Goodbye.
Thank you.
Thank you. Bye-bye.
Thank you so much. Goodbye. Thank you.